The Supreme Court has overturned the landmark Roe decision that established a constitutional right to abortion. It means Roe v. Wade is no longer the law of the land, Rashi.
That's right. Abortion opponents celebrated the court's 5-4 decision after it was released earlier this morning. The ruling said the Constitution does not protect the rights of women to have an abortion. The conservative majority decision is expected to lead to abortion bans in roughly half of the states. This also sets up a trigger law here in Texas. So that means in 30 days, all abortions will be banned from the moment of fertilization, with exceptions only to save the life of a pregnant patient or prevent substantial impairment of major bodily function.
Today, the Republican-controlled Supreme Court has achieved their dark, extreme goal of ripping away a woman's right to make their own reproductive health decisions. Because of Donald Trump, Mitch McConnell, and the Republican Party, their supermajority in the Supreme Court, American women today have less freedom than their mothers.
Today's historic Supreme Court decision is a victory for the sanctity of life. It will save countless innocent children. House Republicans are incredibly grateful for the pro-life movement's tireless efforts for decades, leading to this day to give a voice to the voiceless and protect our most vulnerable, unborn babies.
Shortly after the decision came down, President Biden addressed the country, calling it a sad day in America, and said he hopes the ruling will encourage voters to head to the polls in November's midterm elections.
Dallas appellate attorney David Coale joins us now to talk about the legal ramifications of the Supreme Court's decision. Sir, thank you for your time. Let me start with this. Justice Alito's majority opinion holds that the Constitution makes no reference to abortion. It's 200 plus pages long. Why is that part relevant in sending this issue back to the states?
So Justice Alito, everything clashes in abortion in very controversial ways: life, death, religion, you name it, and how you read the Constitution. And Justice Alito takes the view, as did Justice Scalia, that you start with the text and you look at the history. What was going on when a particular law was put into place? And you look at the text, you don't see the word abortion in there anywhere. You look at history and what was going on when the 14th Amendment was enacted in the late 1860s. Don't see any protection for abortion there. Boom, that answers the question. There are a lot of counter arguments to that, but that's his approach. And if it's not there, it's going to be very hard to convince him the Constitution protects something. Thus, it falls back to the states because our government, our federal government in this country is one of limited powers. If it's not given to the federal government, the states have it.
When you talk about that originalist point of view, which is what this largely relies on, what else conceivably could change, especially when you look at some of the things that Justice Thomas mentioned?
Right, the opinion's written broadly. You can write narrowly, you can write broadly. Obviously, there are a lot of detailed arguments made about the Roe opinion itself, but underlying that is this distrust for the concept of implied rights, of emanations from the Bill of Rights. And Justice Thomas' concurrence makes this very clear. The right of to obtain contraception, addressed by the Griswold case, the gay marriage case, those are going to be up for reconsideration and discussion in the years ahead, citing the analysis of Justice Alito here. There's more to this than just abortion.
So this ruling today notes that previous rulings and arguments relied too much on precedent in the opinion of the majority. But indeed, every justice on the court was questioned before they were confirmed about Roe as precedent. They all said, yep, it is. So what changed?
Nothing. I mean, they all told the truth. They all said they would respect precedent, but the Supreme Court does, in fact, reverse itself in precedents that it believes are poorly decided. There's a test that you apply, and the majority opinion here does apply it. If people thought these candidates, when they were applying for the judge position, Supreme Court position, when they said Roe was precedent, that meant they'd never vote to overturn it, they were naive. That was never a warranty if they weren't going to do this. It really shouldn't be a surprise.
So as we note your civics lesson there, that states have the right ultimately under these circumstances to make these decisions instead of the federal government. Justice Kavanaugh noted that the ruling was made because the law took the decision out of democratically elected representatives. Is that a strong argument?
Well, it's a little bit of a truism. I mean, if the Constitution doesn't take it out of the hands of the states, then the states can do it. That's just a structural way that the government works. The question, though, is should it? must it? And that's, I think, where Justice Kavanaugh's observation is accurate, but not all that relevant. Every right of a minority that the Constitution protects is something that's taken away from the democratic process because we believe that right is important. So yes, it goes to the states, but there's nothing magic about that. That's just what happens when the Constitution and the federal courts step aside and out of the picture.
Puts us on the cusp of a whole new level of conversation, and it starts today. David
Very
Coale
much so.
in Dallas. Thank you, sir. We appreciate you with us.
Thank you.